Hello, welcome to Legal Action. My name is David Siegel. Thanks for joining us today. Today we're going to be talking about the anatomy of a civil lawsuit. Want to welcome in Jesse Barrientos, my co-host. Jesse, welcome to the show.
Thanks, Dave.
You are someone who has brought many civil lawsuits in your career, so you're a perfect person to go through the different steps that one would take.
Great.
And we want to keep this kind of general so that we don't get too specific.
Sure.
Because a lot of people want to know the exact process from start to finish, and I think we can cover it in the time we have allotted. The very first thing we need, Jesse, we need a cause of action.
That's right.
To actually bring a civil lawsuit. Can you give some examples of some different causes of action that one might bring?
Sure. A good example would be just a personal injury case. You get into a fender bender and you can't work it out with the insurance, or somebody doesn't have insurance. That would be a good example. Another example would be maybe a breach of contract. Maybe he had an agreement with somebody. They're not following the terms of the agreement. And the only way to enforce that is to bring that into court and to file a lawsuit for breach of the contract. There are many, many other causes of action. I mean, we could go on. There's wrongful death.
Collection of a debt is a very common one, is it not?
Right, the collection as well. Landlord-tenant, your security deposit. I mean, just so many different. These days, probably should shoot that right there. Is collection of a debt is
foreclosure, very popular.
Foreclosure,
today.
Yep, that's another cause of action as well.
Okay. Would divorce be considered a civil action as well?
Yeah, actually, divorce is.
Okay.
Yeah.
So we've got a number of different lawsuits that are brought every day
right.
in the court system that we consider a civil suit. They all have different statutes of limitations. They all have different elements that need to be proven. But they all have one thing in common to get it started, and what is that? Can you explain that?
Well, that's the complaint. Before you do any cause of action, any lawsuit, you have to file a complaint. Now, a complaint basically lays out the allegations, the facts that lead up to the cause of action. Why are you suing? There's different kind of standard. In federal court, it's what they call just notice pleading, and in state court, it's fact pleading, which means you have to allege the facts. You can't just allege conclusions. And so you want to let the other person has to know what's going on. Why are you suing him? In a personal injury case, generally what you would say is, hey, that on such and such a date, you were driving your car in an easterly or westerly direction on whatever street at such and such a time in such and such a county, and this other person was doing the same thing, and he made contact with your car.
Okay.
He was negligent, go on and on. So you have to lay out all the allegations of the complaint.
So the parties, the facts, the cause of action, the result that happened, and then the relief that you're asking for, whether it be monetary damages or some kind of specific performance, all has to be included in this complaint or petition, if it were. Correct?
Right. Well, petition. You say petition, and be I think more if you're looking for adjunctive relief or whatever. But yeah, in the complaint or petition. Exactly.
Or a dissolution of marriage case is a petition.
Yeah, petition for dissolution. Okay. Exactly right.
Now, incorporated as part of that petition, does the person attach either a copy of the contract, a copy of the lease, something showing damages? How far do they go with attachments?
That's a great question. In fact, you are required to attach a copy of whatever agreement is or lease, if it's a breach of contract case, and that's the subject is a breach of a lease, then you're required to attach that.
Okay,
exactly.
So you're basically putting this person on notice that, here, I'm suing you.
Right.
These are the facts of the case. This is the exhibit attached to show you what I have in terms of damages, and they're served how?
And generally what happens, once you get all this stuff done, and you also have your summons, and generally probably in a case like that, it'll be what they call a 30-day summons, which means after a person gets served, they have 30 days to file their appearance or answer or otherwise plead. But you'll take this to the sheriff if you're in the same county. If you're not in the same county, you may have to get a special process server. Now, it depends on which county because they have different rules depending upon the number of people and the specific locality, whether or not you have to get permission from the court to actually have a process server or whether you can just go ahead and do that.
Now, a process server is, let me just explain that. It's someone in place of the sheriff who is authorized by the court to serve the paperwork upon the defendant, correct?
That's correct. And then also file their affidavit of service that says, okay, on such and such a date, I gave the defendant, this complaint personally, and, they'll do a little description of it, of the person. Or they can do it by what they call substitute service, which is leaving it with somebody 13 years of age or older at the residence, and then they're supposed to also send a copy through the mail as well as that. And then there are other types of service too, but just...
And this all falls under the service of process under the code, putting the defendant on notice that a lawsuit has been served, right?
That's correct. And then also, to serve him, you want to get jurisdiction over that person, have the court get jurisdiction, and so you do that, you effect that by having that person served.
Okay. What happens once this person is served?
Well, then generally they'll have about 30 days to file their appearance, answer, or other responsive pleading. Sometimes, for example, remember I said a little bit earlier that Illinois is a fact-pleading state, and maybe whoever drafted the complaint left a couple things out, and so the person who gets it, they retain an attorney, they look at it, and they think, hey, listen, you know what? They have not pled or alleged the essential elements of this particular cause of action.
Okay.
And so they can file a motion to dismiss, or they can file, that's what you would call, I'm getting maybe a little bit too technical, is a 2615 motion, just based upon defects in the complaint,
right,
or what they call a 2619. Let's say, for example, that we had a car accident and we settled, I paid you. But, you thought that you really didn't, you got shortchanged a little bit and you said, think the heck with me, and so you filed a lawsuit anyway. And so now I file this motion that basically says, hey, listen, there's no cause of action because we've settled it. It's already been resolved. Here's a copy of the release and everything else. So that's one way. Or, and generally, somebody would file their answer, which would be pleading either admitting or denying the allegations of the complaint.
Okay. So the defendant can either try and have the petition complaint thrown out, or they can file what's known as an appearance, basically jump into the arena, jump into the ring, and start to put on their defense, correct?
Right. Well, they're going to file their appearance anyway, but then their answer, that gets you straight. And in fact, you're required under the rules of civil procedure to either admit or deny the allegations, or indicate that you have want of knowledge, that you don't have sufficient information in order to make a decision as to whether or not those it's true or false.
And we should add too, there's court costs involved in the filing of the petition or
That's
complaint,
correct.
And there's also court costs for the person who's coming in and filing the appearance to defend themselves. So this is where the court kind of gets their nest egg that pays for the judges, the clerks, and the infrastructure of the court system.
That's correct, and it depends on how much you're suing for. That will dictate what the fee is going to be. The same thing with the appearance. And then with respect to the with process, if you have the sheriff do it, they have a breakdown, and again, depends whether you're in DuPage or Cook or Will or wherever you're at, the sheriff has a breakdown of how much they charge for mileage and everything to do that. Or if you do a special process server, they have different fees that vary.
Yeah. Well, I think I'm a proponent of a flat tax, and I'm also a proponent of a flat tax in terms of lawsuits, but that's another item we can get into later, because really, if you have a cause of action, why should you pay more based on the damages? You have a cause of action, you want redress before the court system, I think you should have access to the court for the same fee. But that,
well, you could, but I guess more would be involved if you have, for example, a small claims case where you're suing somebody for a couple $1,000s versus this much larger case where you're suing somebody for $150,000. There's going to be more work that's involved. But you look at the poor guy. What is it going to be? Where are you going to do it? How are you going to break that up?
But as you know, a small claims case can also go to trial.
Oh, sure, but there's things.
The judge can allow discovery in a small. You can have a small claims case that blows up into a major case.
Sure, you can.
But anyway, both parties are served. They're ready to come into court. Hopefully, they have their lawyers. They're ready to move the case forward. What happens next?
Well, one of the first things a lot of people do is to do discovery, which is you send out what they call interrogatories, which are answers to specific questions. And they have, in fact, standard interrogatories for automobile cases, for other types of cases.
Okay, let's break this down for the layperson who doesn't know what discovery is, doesn't know what an interrogatory is. It's fact-finding, is it not?
That's exactly what it is.
Okay, so they're trying to find out information from the other side. And they can do that either in writing, making them answer specific written questions. They could also take their testimony at a deposition, correct?
In fact, a lot of times you do it all those ways. You do the interrogatories, which are questions, notice to produce, which are documents you want the other side to produce, and then also after you have all that stuff, then you take the deposition, which is you sit in a room with the court reporter, and a person takes everything down, and you ask those persons questions, and so you get them, their testimony gets locked in, because again, it's you're under oath when you say that. So those are all forms, just like you said, of fact finding to be able to develop your case, and for the defense to be able to develop their defense.
Okay. Once you've completed discovery, and once the other side has completed discovery, everything is kind of laid out in terms of what's involved in this case, what eventually may come before the court if it goes to trial. Is there anything hidden, or is basically everything laid out on the table? And this is what we have here. Can we reach an agreement?
Well, you might want to, to try, I mean, there's a whole bunch of different ways you can go. You might want to try to just settle it amongst the parties, to see what you can do to resolve it. And sometimes that'll even happen before discovery.
What's the likelihood of that?
Well, I forget what the percentages are, but I think a very small percentage of cases actually go to trial. And there's a good reason for that. There's the old saying, a bird in the hand is worth more than two in the bush. But you never know what's going to happen. Also, litigation can continue for years. Litigation is also expensive. If it's your simple, car accident case, and you have to have a doctor come in, you have to pay the doctor. You have to, take the doctor's deposition. The other side will do that, and very often it's $500-600 an hour with a minimum of so many hours. And there's a lot of time and effort and costs.
And most importantly, you don't have any idea what the result's going to be.
Don't know what it's going to be.
Don't know how a judge is going to rule. You
Or
certainly
jury.
don't know how a jury is
Right.
going to rule. It's gambling to a certain extent. You're taking your argument to the court, and you really don't know what's going to happen. So it might be best to strike a deal and compromise, as opposed to an all or nothing kind of decision if it goes before the court or a jury.
Yeah, if you can. And so, the thing with that, though, is that, very often people make it it's a matter of principle sometimes, and, people aren't reasonable. If it were reasonable, really you wouldn't have, a lot of the court intervention. So if you can't get it taken care of amongst yourselves, then sometimes it's helpful to set a pretrial conference with the judge.
Okay. Pre-trial. Explain to the listeners what that is.
Well, this is before the trial, and it's a way. It's the judge is basically going to give his recommendations. Generally, do a pretrial memorandum to lay out before the judge kind of what the basic facts are, what the contentious issues are, and so he gets a little able to prepare a little bit. And then when you go back and you talk to the judge, each party presents things to the judge. It kind of gives him their argument that normally he wouldn't be able to hear otherwise, and he'll render his recommendation. He'll say, well, I think basically that it might be this.
But wait, Jesse, the judge hasn't heard one witness.
Right.
The judge hasn't heard one witness be cross-examined. The judge hasn't probably touched any of the evidence or even looked at many of the exhibits or anything. They're basically going off the pretrial memos that counsel for each party has prepared. What's the likelihood of that judge getting a real handle on this case? And two, how much time does the judge put in to really try and get a handle on the case?
Well, I guess it depends upon the specific judge, and it depends upon the complexity of the case. But also, though, I mean, generally, the issues are kind of refined. I mean, a lot of times, okay, what's the issue? The issue is I have this amount of money in what they call medical specials. In other words, medical bills that I've paid, or prescription drugs, or time off from work, or whatever. And I'm looking for this huge, larger amount to compensate me not only for that, but also for my pain and suffering and everything else. And so you have the attorney for the defense. And again, I'm just speaking about maybe just a personal injury kind of case. We want $50,000, and they want to give us $3,000. Okay, and a lot of times, and maybe we can get into that just a little bit. There are differences between what they call soft tissue cases and hard tissue. Soft tissue would be like a muscle injury. It's treated by chiropractor or either orthopod. I mean, there are just many ways to treat that. Or a hard tissue, which would be a broken bone.
A fracture, hospitalization.
Exactly.
Treatment by an MD.
Right. And you can even have that with soft tissue, but generally soft tissue cases are more problematic because it's more difficult to prove them, and people, juries especially, don't look so very favorably upon giving an award. But generally that's what you have, and so it's just a question of that. And then the judge will spend, again, depending upon the judge, he'll spend, decent amount of time with you if you're making progress. If we're wanting 50 and you're only offering 3, and that's it, I mean, you're way apart. And so very often people make their demand, they make it larger because they know what the other side's going to come back. You highball, you lowball, and somewhere in between. And the judge will give a recommendation. A lot of times they will just take each party out and talk to them, and then go back and then see where they're at without sharing with the other side what your bottom line or what your top line is in terms of what you're going to pay. And really, they really try to resolve it because it's in everybody's best interest to do that.
Now, if that judge is going to be the judge who's going to be actually hearing the case, which is known as a bench trial,
Yep.
I would say that pretrial recommendation carries a lot of weight because the same parties are going to have to bring their case before that judge. But in a case where the evidence is going to be heard by a jury, the judge's recommendation is not as important because the jury is the one that the parties have to convince as to their side. Would you agree with that?
I would agree with that too, but also understand the judge is the referee. The judge is the one that controls everything that's going on. The judge can entertain a post-trial motion to reduce a verdict or for a judgment notwithstanding the verdict. And so, you certainly want to take his recommendation seriously. But again, it's just that a recommendation. It's another interesting thing that you mentioned, since he's going to hear all that stuff. Generally, they give the admonishments to both sides that they, understand that the, attorneys are going to come back and talk to the judge and let him hear information that he might not hear, or might be evidence that might be inadmissible in a trial, and that once they have that pretrial conference, that the parties cannot, substitute him. In other words, try to get another judge just on the basis of they don't like what the recommendation is. So once you do that, you're stuck unless it's for cause.
Okay. Well, let's say I represent the plaintiff in this case, which is the person suing the other party, and we've gone through a pretrial conference. The judges kind of made their recommendation. Let's go with the injury case. They've offered, or the judges recommended, a settlement of $10,000.
Right.
I turn to my client. I talk to him about it, and the client says, "No way. I'm entitled to much more. I was hurt. I lost this amount of work. I can't do this anymore. I've got some permanent disability now." And my client says, "I don't accept it." Our only opportunity at that point is to go to a full trial. Is that correct?
Well, it's to go to a trial, or I've had some other cases where people do binding or non-binding mediation or arbitration. So basically, what that means is, if it's binding, that means whatever the arbitrators say, whatever their decision is, you're stuck with it. If it's non-binding, it's just a recommendation. Or you have mediation too, which again is more extensive. There's a cost to both parties, and generally, there are a lot of good mediators out there. A lot of them are retired judges, and they spend much more time, pretty much as much time as long as both parties are making progress to try to reduce that. And it's based upon the strengths and weaknesses of each respective position. And so that's why sometimes it's important to get your discovery done so you know what's going to happen on either side.
Well, all that's failed in this case. So now we have to prepare for a trial.
Then you're going to trial, right?
Okay. Let's go through the steps that are involved in preparing for a trial, because it's not something that happens overnight.
Well, you have all of your discovery. Hopefully, you have deposed your witnesses. In other words, the people that the other side's identified who have knowledge of the facts of the case. You've taken their depositions, so you have everything done and prepared. You've subpoenaed documents from independent third-party sources, so that you have all of that information as well.
Okay. When do you start preparing your opening statement, your closing statement? Do you have that all done in advance if you're doing the trial?
Yes, you have to prepare ahead of time, and so it depends again upon the complexity of the particular case.
Auto injury case.
Auto injury case. Probably if you have your trial and you're set for a jury trial, and you're going, then I think you probably want to start preparing. Well, all this fact gathering, everything is part of the preparation process, but assuming that you have everything together, you probably want to start preparing, months ahead of time.
Jesse, when it comes to preparing for the trial, approximately how much time is involved in getting yourself ready and getting your client ready for this trial?
Well, it really depends on the type of case, how complex it is and everything else. It could be anywhere from, maybe 10 hours to 40 hours to 50 or 60. It just depends. I also like to think that part of the trial preparation, too, is going through the discovery and everything else. You've gone through that. But now when you're coming to the preparing stage and you've already done that, you have to review the transcripts. You have to review the documents. You have to review the medical records. And, you have to prepare your opening statement and have a good idea to know.
Let's talk about that. The
Sure.
trial dates arrive now. You show up at court. You're the petitioner, you're the plaintiff, you're
Right.
the one bringing the case.
Sure.
You're going to start.
We're going to start. You're going to.
What are you going to do?
You're going to do your opening statement. Actually, first, there's going to be what they call any pretrial motions, for example, to exclude witnesses, because you don't want the witnesses to hear, the testimony of the other people. And that's a motion, pretrial motion, that most people will judges will generally grant, because it just makes sense. Also, you might have motion limine. In other words, there's certain evidence that you don't want to come in, and so you want a ruling on that before the jury kind of hears that. And they may not hear that, in fact, because the judge will probably have them go back to the jury room. But you want to try to get those preliminary things off of the plate before you go ahead and you actually start the trial.
So there's actually a framework before the trial starts. You kind of know which evidence is going to be
Right.
presented, which will not be presented, who's going to testify, who's going to be permitted to sit in the room. Kind of like the ground rules are being set by the court.
Right.
And then they turn the ball over to you and say, counsel,
Well,
bring your case.
Bring your case. Actually, before you even get there, you have to pick the jury if it's a jury trial. And you have people in the jury box, the veneering men, and you're entitled to ask them questions. I'm sure most of the folks out there have been to, have received jury duty. Some of them may have even been lucky enough to be on a trial to kind of observe some of this stuff firsthand. But there are questionnaires that you fill out, and so the counsels, the attorneys get a chance to look at that, and so does the judge. Each judge does it a little bit differently. They allow you to ask questions to find out whether or not this person is going to be a good person for you, if there are any prejudices. Let's say, for example...
What are you looking for in a jury?
Well, if we're looking for if it's just a personal injury case kind of thing.
Right.
What I'm looking for is, I just want somebody who's going to be, impartial, unbiased, somebody who, for example, doesn't have a thing against chiropractors or against a specific doctor or those kind of things. Maybe somebody who has been in an accident before, because they can identify and experience those things kind of firsthand. I want somebody who's going to be pay attention and who's going to listen and who's actually going to apply the rules and the law that the judge gives them, the instructions, at the end of the case. I want somebody who is going to pay attention.
Okay, so the jury is picked. You're ready to go. The judge says, counsel, bring your case. What do you do?
You start with your opening statement. I mean, you can waive it, but with the jury, with a bench trial, which is just in front of the judge, you can waive it, but, a lot of times you like to just sum it up, give them an idea. But with the jury especially, you want to let that jury know what you expect the evidence is going to show. I want to go out there and I want to look at them. I want to look each and every one of them in the eye, and I want to tell them, hey, this is a case. I want to tell them what the nature of the case is. And I want to tell them, hey, I expect the evidence is going to show A, B, and C. And I expect the evidence is going to show that the doctor is going to testify and he's going to say that it's a direct result of this car accident that my client is injured, and it's a permanent injury. And I expect the evidence to show also that we have this amount in damages, and this economist maybe is going to testify, and that's what I expect the evidence to show. But you want to prepare it, you want it to be eloquent, you want to know, and that's part of the preparation, you want to know your case inside, outside, backwards, forward, upside down.
Okay, so you're trying to be persuasive right off the bat. You're trying to sell what you're going to be bringing to the court, and you want to sell the right of your client to prevail.
You do, it's your personality, but I mean, generally in the opening statement, again, it's not supposed to be argumentative. It's just supposed to be, I'm supposed to be, telling them what I expect the evidence to show. And it's very important and crucial because, if I miss something and I tell them that I expect the evidence is going to be this and this person is going to testify this way, and it doesn't happen, a good defense attorney on the other side, in the closing argument, and we'll get to that later, is going to turn that around on me and say, well, hell, you heard Mr. Barrientos say that he expected so-and-so to testify about this and that, and he expected the evidence to show this and that. That's what he told you. That's what he promised you in his opening statement. But what did we see?
Right.
I mean, you can go either way.
So the defense gets to make an opening statement as well.
That's correct.
Once the openings are done, where do we go from here?
Well, then the plaintiff calls his first witness. And then, depending upon what witness it is, I mean, there's a strategy in terms of...
This is called direct testimony.
Direct examination, that's correct.
Direct examination.
Right. And, I'm trying to elicit facts. Hopefully, I mean, again, if, your witnesses, you've worked with them, you've prepared them. And when I say prepare, I tell all my folks what I expect from my witnesses is to tell the truth. But I also expect them, not to over-answer the question. In other words, just answer the question that you're asked. And that's it, and kind of go from there.
What is cross-examination of your witness?
Well, after the plaintiff has an opportunity, or the plaintiff's counsel, attorney, has an opportunity to question whatever witness he's chosen to call, then the defense attorney gets a chance to go up there and to kind of cross him and ask him questions about his testimony. So, for example, let's say you testified that you were going 25 miles an hour. In a 30-mile-an-hour zone there, and this guy just came out and hit you going 50 miles an hour. But in your deposition testimony, you said something else, right? You said you were going 60 miles an hour. Well, he's going to bring that out.
Okay. And that's called impeaching the witness.
That's called impeaching the witness. Now, hopefully, your attorney would have seen that, and those are the things you go over to make sure there's consistency in what you said before. And yeah, that would be called impeaching the witness. And so it gives the defense an opportunity to question the credibility, to break down their claims, and to also let the jury see how this person is going to act under pressure, what their poise is, what their demeanor is.
Okay. This happens with every witness for the offense as well as every witness for the defense.
After the plaintiff is through with his cases and he's called all of his witnesses, the plaintiff can rest, and then very often the defense will do a motion for a directed verdict or a directed finding, basically saying that, hey, the plaintiff has not made out the elements that they need to make out for their cause of action, and therefore it should be dismissed.
And that motion is often denied.
It's often, especially in a jury trial.
Okay.
Yeah, unless it's really egregious. I mean, it certainly does happen. And then the defense counsel, they get an opportunity to call their witnesses.
And they do the same thing.
And they do the same thing, except when they do it, they're asking that person, their witnesses, under direct examination, and then the plaintiff gets to cross-examine their witnesses to try to bring out the biases.
Take me through the close briefly.
Well, then when you're all done and everything, everybody is rested, then the plaintiff has an opportunity to do his closing argument. And what they want to say is, they want to look everybody in the eye, and you want to talk to them, and you would tell them, hey, listen, remember in the beginning, I told you that the evidence was going to show A, B, and C, that this doctor was going to testify this and this person was going to testify that. You've heard what the evidence has established. You've heard exactly what I promised you in the opening statement was going to happen. You've heard he testified that as a direct result of the defendant's car coming and colliding with my client's car, that he's now permanently damaged. You've heard the testimony from the economist that says it's going to take, he's basically at a loss for, $75,000 or $100,000 or whatever the case may be. You've heard that testimony. And I want you to go back there, and I want you to review the evidence very carefully, and I want you just to make the decision that you promised you were going to make in the beginning, which was you were going to review the evidence, and if the plaintiff proved his case, that you would act accordingly. How much should you award the person? That's up to you. There's just all many different ways to do it.
The other side makes a close, and then it's in the hands of the jury at that point. Right?
But sometimes, if the plaintiff reserves the rest of their time for the closing statement, they will get the last word. So then, after the plaintiff does his closing statement, and then the defense does their closing statement, then the plaintiff gets the one last opportunity to speak, and that's only right too. Again, depends upon the judge. Depends if you reserve the time. Interesting courtroom decorum. The plaintiff, the person who has the burden of proof, gets to sit either closest to the jury or closest to the judge, depending. Okay. That's just a little background there, courtroom decorum. But then you get an opportunity, and that's why it's very important to pay attention and to listen to what the defense counsel is saying in their closing argument. So you want to pick out little things. And then, again, it just depends on the specific facts and the specific case. Then you give your rebuttal, and you respond to what the defense said in their closing. And then what happens is the jury gets their jury instructions, which you've done ahead of time, by the way. That's part of the preparation and everything else. And you argue over jury instructions. Very often there's a jury instruction conference, either before the trial or day before or sometime before, and then they retire to deliberate. Okay.
And it's in the hands of the jury or in the hands of the judge, and you wait for the decision.
And you wait for the decision.
Okay. Jesse, great job. Thanks for taking us from start to finish on a civil trial, a civil lawsuit that goes to trial. Thanks for joining us on Legal Action. We'll see you next time.